Does anybody know what type of case you do not need to bring in a medical expert to testify in a malpractice case? Anybody? It involves a 3-word Latin phrase, and you all know what that phrase is. I'm going to tell you in a second. Anybody? What I hear? Res ipsa loquitor. Okay? The thing speaks for itself. Right? We all know it from documents. But from an evidence standpoint, remember, in a malpractice case, we are required to bring in a medical expert to support every one of the elements of our claim. If we don't have a medical expert, we can't get our foot in the door. We'll get dismissed on summary judgment after we make our opening remarks. So we need a medical expert, but there's only one type of scenario where we don't. And that's in the case, and I'll give you a great example. A gentleman goes in for hand surgery on his left hand. He comes out of surgery with a big bandage over his right shoulder, and he's told that he suffered a 3rd-degree burn on his right shoulder. How is that possible? The patient goes in for surgery on his left hand, comes out with the surgery being done, but he also has a 3rd-degree burn to his shoulder. How is that possible? Well, the answer is, it shouldn't happen. The patient was under the sole and exclusive care of the doctors in the hospital. He was under anesthesia at the time. So how is it physically possible that he might have contributed or caused his own injury? Where it becomes obvious and apparent, and you don't need a medical expert to tell a layperson that, hey, if you're going in to have surgery on your left hand, you should not come out of surgery with a burn injury to your opposite shoulder. It's just obvious, right? Well, the law in New York says, in that instance, you don't need a medical expert. You can rely on the legal doctrine known as res ipsa loquitor. But I will tell you, the better practice, even though you don't need a doctor to do that, you still want to have one to come in and testify to support your claim, and here's why. It all goes back to the defense argument. And you know the book title that I have, Doctors Gone Wild? Well, one of the outrageous claims that have come up in the past is in this exact scenario. In order for the client, for the patient, to get the benefit of not needing to bring in an expert, we have to show that the doctors and the hospital staff were in exclusive control of what happened. And this typically will happen when a patient is under anesthesia during surgery. But I have seen this defense being raised. Here's what happened, and here's why we're not responsible, the doctor argues. During the course of the procedure, although the patient was under anesthesia, they suffered an uncontrollable twitch. And as a result of that, that twitch caused the patient's hand to fly up, hit the doctor who was holding a cautery device, a burning device, to close off bleeding vessels, that caused the drape to catch fire, that caused the 3rd-degree burn to the patient's shoulder. And therefore, you can't hold us accountable for that happening. Why? Because the patient was in control, even though they had some anesthesia, and now you still need an expert to come in and say how that's physically impossible and that never should have happened. So even though you can use that doctrine to not have to bring in a medical expert, the better practice is always to bring in the expert and not have to rely on the possibility that the defense is going to raise one of their Doctors Gone Wild defenses to now show that, hey, this patient should not have done what they did and contributed to their own injury. And if it turns out a jury believes them, we're going to lose on that claim. So that's why you always will need to have an expert come in to testify about departures from good care, that the departures were a substantial factor in causing and bringing about injury, and that the injuries are significant and permanent. Now, you may find from talking to your client that the injuries that they have are not that significant. They may have bruising. They may have something that occurred because of something done wrong, but it's just not that significant. Is that the type of case that you want to handle or send out to an experienced attorney? The answer most likely is no. The injuries need to be significant enough to justify making a substantial investment in prosecuting the case. So if you only have bruising, my suggestion is that's not going to be the right type of case for an experienced med mal attorney. If you have fractures, need another surgery, if you have something more substantial, that may be the right type of case to pursue and investigate. Now, what do you do in the instance where you've now identified that there's something going on here? You've now made a determination that in all likelihood, this case is timely. You've now filtered in your own mind that certain time frames apply and that this case probably is timely and that there is continuous treatment or something along those lines. What do you do next? Well, what you do next is you have to determine who are the possible defendants. Who are the people involved here who committed the wrongdoings? Is it a resident who works in a hospital? Is it a private attending? Is it hospital staff? Is it nurses, technicians? Who are they? And I bring this up because it's important to understand vicarious liability. And for those of you who are unfamiliar with it, vicarious liability simply means that the employer is responsible for the acts of the employee. So if you are working in a hospital, if you are working for a medical group, you must always include the medical entity, the hospital, the medical group as part of your lawsuit. So just keep that in the back of your mind as you try and understand whether or not, who are the possible defendants.